Good afternoon. It is January the 6th, 2014, and I am going to discuss the toxic chemical release obligations under federal and state law, dealing with what's known as the Community Right to Know Act, emergency planning, referred to as EPCRA, within the confines of the Comprehensive Environmental Response Compensation and Liability Act under federal law known as CERCLA. Commonly, these two laws are mentioned together. And in my discussion, I want to reaffirm the fact that the Guzman Law Firm, where I practice, does engage in the practice of law and does provide legal advice and opinions. However, the information contained in my presentation is not and should not be construed to constitute legal advice for you and the company on this matter or any other. If you wish, you should engage counsel of your own choosing to analyze any situation that may come to mind for you and your company in this regard. The Emergency Planning and Community Right to Know Act, also known as EPCRA, was passed in 1986 by the federal government, and its basic design and purpose was to help communities plan for emergencies when you have the hazardous release of chemical substances from facilities and operations. What EPCRA does is it requires hazardous chemical emergency planning by federal, state, and local governments, Indian tribes, and industries. And it also requires the industries to report on the storage, use, and releases of hazardous chemicals to the federal, state, and local governments. EPCRA actually was passed following the infamous Bhopal, India, disastrous chemical release situation occurring in 1984. And there was a accidental release of a hazardous chemical, and it killed hundreds of people and injured several thousand people in the mid-1980s. That became obviously a concern to Congress following that incident, and Congress decided to obviously pass laws, EPCRA CERCLA laws, that deal with the reporting of, handling, and release of hazardous chemicals into the atmosphere as a matter of EPA program compliance. It's commonly referred to as the Community's Right to Know law on a reporting basis concerning hazardous and toxic chemicals. The EPCRA Community Right to Know provisions help increase the public knowledge and access to information on chemicals at individual facilities. The use of the chemicals and what can happen if such chemicals are released into the environment. Now, anyone is free actually to go down to your local city or county government, or checking through the state government if you wish, and federally, but to find out what facilities in your community actually store, handle, and could be subject to hazardous chemical releases, so that the citizenry is informed about chemical safety and how their environment can be impacted if there is a chemical release. And as I will discuss further in this presentation, as a facility containing hazardous and toxic chemicals, you may be required to file plans with the local government on the subject, discussing worst-case scenarios if there is a release, and how that works within the framework of the EPCRA CERCLA law. To begin with, under sections 301 to 303, emergency planning, local governments are required to prepare chemical emergency response plans and to review plans at least annually with their local government officials. State governments are required to oversee and coordinate local planning efforts at the city and county level. And facilities that maintain extremely hazardous substances, commonly referred to as EHS, on-site in quantities greater than the corresponding threshold planning quantities, must cooperate in emergency plan preparation. So, as you'll find out through the course of this discussion, if you are a facility that maintains certain quantities of extremely hazardous substances on your facility site, you are required to prepare a plan of action if there is a release on the threshold of impact of that release and coordinate such activity with the local emergency fire departments and hazmat concerns that would be responding to such releases. Facilities must immediately report accidental releases of EHS chemicals and hazardous substances in quantities greater than corresponding reportable quantities defined under CERCLA to the state and local officials. Now, this information, while available to the public, means that for facilities, they must know what constitutes hazardous substances. They must know whether or not they exceed the minimum thresholds that do require reporting of the quantities and nature of the chemicals to state and local officials. And we'll discuss that a little bit further as I proceed. Now, under sections 311 and 312, under EPCRA, facilities manufacturing, processing, or storing hazardous chemicals, they must have MSDSs, now they're just called safety data sheets, available to state and local officials and fire departments. The SDSs describe the properties and health effects of the chemicals, and the facilities must also report to state and local officials and local fire departments inventories of all on-site chemicals for which the SDSs exist. And all this information is made available to the public when the community right to know reporting and plans are filed with your local and state governments regarding the hazardous chemicals at their site. There is an important toxic release inventory, which is known in environmental law as TRIs, where facilities must report online and or in writing a toxic chemical release inventory Form R. And this is done annually, and the Form R must be submitted for each of the over 600 chemicals that are manufactured or otherwise used above the applicable threshold quantities. You do not need to report a chemical that falls under the threshold quantity, but every facility should know what they have on site by way of what those quantities are. And we'll discuss a little bit later an example of what that means and how it works. Now, just very quickly, the basics on toxic release inventory reporting are outlined for you on this government printout, which is a fairly good illustration informing you that you must prepare and submit your forms January and February, no later than the end of June, at which time you are supposed to have filed your TRI inventory. And you end up having the government take this information that's reported on or before July 1 of each year, and it's inventoried and analyzed by the EPA and through state EPA enforcement programs on an annual basis as well. And depending upon the concerns that the EPA may have or state enforcement programs, they may focus on certain chemicals such as ammonia, which is a very common hazardous substance that is regulated by EPCRA CERCLA. On the reporting criteria, do you or do you not have to report? If a facility meets all three of the criteria that is listed on this particular PowerPoint page, it must report to the TRI environmental program at the state and federal level. First of the criteria is the industry in a specific industrial sector, manufacturing, mining, electrical power generation, etc. Does the facility employ 10 or more full-time equivalent employees, and manufactures or processes more than 25,000 pounds of a TRI listed chemical, or otherwise uses more than 10,000 pounds of a listed chemical in a given year. A facility must submit the TRI form for each TRI listed chemical it manufactures, processes, or uses in quantities above the reporting threshold, and must submit each TRI form to the EPA and to the state enforcement programs in which the facility is located. Now, there are two methods available to regulated facilities for submitting the TRI data to the environmental agencies. There's the web internet site process where you do online reporting. And facilities are, of course, encouraged to use the fillable printable TRI forms if they need to submit their forms hard copy as opposed to going online. Now, the Act under Section 313 of EPCRA is what created this TRI program. All U.S. facilities that meet the TRI reporting criteria must submit the data to the EPA the middle of each year on or before July 1. The compliance resources include inspectors and attorneys at all of the EPA regional offices in the United States and their headquarters. It's a separately managed and functional program from an oversight standpoint. And if facilities don't report their inventories as they are required to do so, or if there are releases that occur that are not timely reported, as will be discussed, there are potentially significant civil and criminal fines and penalties that can accompany a violation. I give you on this particular PowerPoint page some recent examples of fines that have been imposed by the EPA for chemical reporting violations under EPCRA CERCLA. And while the penalties, are in the tens of thousands of dollars on the examples I've given to you, they can approach up to $25,000 a day for failing to, say, timely report a chemical release, or even incorrectly reporting what they should be, or failing to report at all. And it depends upon the circumstances as to what those civil penalties will be, but keep in mind that violations of EPCRA CERCLA can also involve criminal liability, both as to the facility and responsible managers who fail to comply with the reporting requirements under EPCRA CERCLA. Not oddly enough, but equally of concern should be the fact that farmers are subject to the EPCRA CERCLA reporting laws. There are 4 major reporting requirements under EPCRA. The emergency planning notification, the emergency release notification, and such a release should occur, the community's right to know on safety data sheets, and emergency and hazardous chemical inventory forms and toxic release chemical forms that must be filed. Now, farms are not exempted, as I just mentioned, since the law was designed to generally identify all facilities that have any of the listed extremely hazardous substances present in excess of the threshold quantities. Those threshold quantities are based on the amount of any of these substances which could, upon release, present human health hazards which warrant emergency planning. Now, the key threshold normally runs to the property line, so any release off-site must always be reported, especially if there is the potential for an off-site exposure that can affect human health and pose a hazard to people. What they refer to as the TPQ emergency planning triggers based on these public health concerns rather than the type of facility where the chemicals might be located. That's why when you are a facility that must report to federal and state government about the existence of one or more of these hazardous chemicals, that information is included in a report that is filed and maintained with state and local authorities, which will include a worst-case scenario in terms of potential hazardous release of chemicals and how that impacts off-site from the facility. If there's a cloud of ammonia, for instance, or chlorine that might be crossing the property line when there's a release on site. So the emergency planning community right to know includes descriptions by the facility that are filed with the local and state authorities on what those worst case scenarios might be, and they almost always involve exposure to human health as a hazard. When you're dealing with farms, you of course are more in a rural location, and therefore the potential for human adverse impact on human health is less, but may still exist, especially if you have other rural houses and communities close by. There are large volume storage concerns that the farming community needs to be made aware of in order to make sure they aren't overlooking the need to report. Now, EPCRA was established to create state and local planning organizations and notification requirements to meet these needs. Therefore, you do have local emergency planning committees, which is at the most extreme local community situation with involving your local fire department, your hazmat units at the city and county level. And to meet the emergency planning requirements of EPCRA, farm owners and operators must determine if they have any of the listed extremely hazardous substances in excess of those threshold planning quantities. And they need to inform your local emergency planning committees through the reporting obligation for worst-case scenarios that is on file, so that the local emergency planning committees will know how to respond. If a farmer, for instance, is in a situation where he may not have the chemical stored for long on the property and still report the existence of such chemicals. As I move forward on emergency release notification, farmers, like any other industry or factory facility, is required to report releases to local, state, and federal authorities, which we'll discuss shortly. if there has been a release, a minimum threshold release of such chemical into the atmosphere. So farmers are not excluded from the commercial and industrial facility reporting requirements simply because they are in agriculture as opposed to industry and commercial activities. You have a very important obligation when you are a facility in terms of needing to make an immediate report once a release is detected. And the reporting requirement is actually threefold. You need to report a chemical release if it meets a threshold minimum release requirement, which I'll show you toward the end of the presentation by illustration, to local, state, and federal authorities. You have a National Response Center, which is the federal government response center at the 800-424-8802 number. It's been in existence since the early 1980s. And if you have any of the hazardous substances listed under CERCLA, you must call the National Response Center, and that call must be made as soon as possible upon the discovery of the fact that a release has occurred. There are a number of questions that are asked of facilities when they make that initial National Response Center call, some of which may or may not be answerable at the time. They're asking for background information and estimated quantities, which may not be known at the time. But in the end, that call is required. And if not made, you can be prosecuted civilly and subject to fines and penalties for failure to make that notification if a release has occurred. Now, that does not eliminate the need to contact the state environmental agency, which is referred to as CERC, and then local emergency planning committee. And as a facility, you need to have in place the address and phone numbers, not only for the National Response Center, but for the state numbers to call in the event there has been a release, a reportable threshold release of a hazardous chemical. Those numbers vary from locale to locale, starting with your local emergency planning committee, then up to the state. States have their own environmental agencies. Normally it is that number with the state that will be department specific that you are required to call after contacting the National Response Center. That notification should really occur in sequence, starting with the National Response Center, followed by the state, and then the local emergency planning committee number. And depending upon the jurisdiction you are in, you will be required to submit a follow-up written report to the state and or to the local emergency planning committee on the facts concerning the release. Also, when you do report to the National Response Center, they generally follow up with a form that has to be filled out and returned to the federal government on that release as well. So you are going to open up a reporting obligation in writing that must follow the verbal reports made to the national, state, and local agencies that I have talked about. I won't get into what exemptions exist for reporting, but it is mentioned on the PowerPoint presentation. Moving forward, under the community right to know reporting sections, I encourage all facilities to make sure that they have the up-to-date safety data sheets that are required by OSHA to be available on-site at all facilities. Those need to be updated and maintained and also accessible to employees as well. On all hazardous chemicals, used at that facility. They may not meet the threshold for reporting requirements if there is a EPCRA CERCLA release, but OSHA covers just the mere presence of chemicals, regardless of quantities that employees are exposed to, that must require the facility to maintain their safety data sheets on site. EPCRA includes numerous provisions for civil, administrative, and criminal penalties. And let's not forget citizen lawsuits for failure to comply with requirements of the law. Sometimes citizens will file lawsuits against facilities if they feel that the federal government or state enforcement programs are not enforcing the law as they should against a facility involving the handling and release of hazardous chemicals. The long arm of the law extends beyond the government itself and gives citizens the right to sue a facility, which is all the more reason that a facility needs to make sure it is in compliance with EPCRA CERCLA hazardous chemical reporting and releasing requirements. Again, I want to talk about further exemptions, but when there is a release of a hazardous chemical that is included under EPCRA CERCLA, and if that release is beyond a minimum threshold amount, notification, as I have been discussing at the federal, state, and local level, is required. Now, when you make such a report of a release, and I'll just use the example of anhydrous ammonia. If you're a facility that's cold storage or uses ammonia in their processes, you're likely to be required to report the stored quantities at your facility, which in the case of ammonia, if you have 10,000 or more pounds of anhydrous ammonia on site, you need to report that. And then if you have a release of that ammonia, 100 pounds or more within a 24-hour period, you must report that to federal, state, and local authorities. So when you make that report, or say starting with the phone call to the federal government, they're going to ask information such as the chemical name or identity of the substance, an indication of whether the substance is an extremely hazardous chemical, an estimate of the quantity of any such substance that was released into the environment, the time and duration of the release, the medium or media into which the release occurred, and any known or anticipated acute or chronic health risks associated with the emergency, and where appropriate advice regarding attention necessary for exposed individuals. Proper precautions to take as a result of the release, including evacuation. Was the source of the release located, isolated, and eliminated? And the names and telephone number of the person or persons to be contacted for further information. Now, on what information you're being asked to provide when you do report a release, you may not be able to provide all the information they're asking for. For instance, you may not know at the time exactly how much of that hazardous chemical has been released. It may be a 10-pound release, a 100-pound release, 1,000-pound release, you may not know. You generally can tell if it is of any significance. It probably is exceeding the threshold, but it may not. But the question then is, if you as a facility manager are made aware of the fact that a release is occurring because a maintenance person has notified you at the time of their detection, do you or do you not report it? Good advice is to the effect that you report all releases that you suspect may be exceeding the threshold of an incidental type of release. And err on the side of caution, because failing to timely report a hazardous chemical release can result in significant fines and penalties, including criminal prosecution. Now, there is no crime in having a release occur on your facility property. It can be a crime and a civil violation if you fail to report the release, especially if it's off-site as an impact. So a lot of people confuse or have the notion that if they report something as having occurred by way of a hazardous chemical release, they're absolutely going to be fined and penalized. And the answer is no, that may not be the case. There are other factors that may come into play later. For instance, OSHA may show up on your property to investigate the release because it may have involved noncompliance with OSHA Process Safety Management Program regulations. But the mere fact the release occurs is not in and of itself grounds to believe a violation has occurred, unless you can prove a regulatory noncompliant act that impacted and caused the release to begin with, or there was noncompliance in how the response took place after the release was detected. The verbal summation of information which you are asked to provide over the telephone when you do report a release, as I mentioned before, will normally require follow-up reporting in writing, which may have more specific information later on when you make those reports. And depending upon the jurisdiction you're in, the filing of that written report will vary from 24 to 48 hours to 7 working days. Just depends upon what jurisdiction you're in. Now, the fact that no one is hurt by a release of a hazardous substance does not mean that it shouldn't be reported. Oftentimes, if you have a facility that is properly managed, there will be a program in place for an immediate evacuation of a facility, even if the amount of release of the hazardous chemical does not meet the reporting threshold. You may have an incidental release of ammonia in a production facility, which is detected at a low threshold level by the human nose and may trigger alarms that results in a facility evacuation, after which time if the facility is aired out and it's safe to re-enter, that airing out of the release may not need to have been reported. And so when the alarms are triggered and there's notification that people need to leave the plant or the area, that does not mean it must be reported. You'll have to determine the nature of the release, if at all possible, to judge whether or not there's a mathematical computation that you can do to ascertain an approximate quantity release. But again, if you're ever in doubt, you should report the release, even if in the end the follow-up investigation determines that it fell below the threshold that triggers mandatory reporting. As soon as practical after a release, which requires notice, the facility must provide follow-up emergency notice, setting forth and updating the information required when you verbally report it. And the additional information can hit upon actions taken to respond to and contain the release. It will deal with any known or anticipated acute or chronic health risks associated with the release. And what that means is were people taken to the hospital, seen by doctors, following their exposure, and where appropriate, advice regarding medical attention necessary for the exposed individuals. I'll bypass the transportation discussion, but obviously if you have a hazardous chemical on a route being transported in tankers, and there has to be a release, say, while the unit is transferring, say, ammonia from the tanker into the plant itself. Those type of releases must be reported. Now, I want to review the penalties in the event that a facility fails to comply with its mandatory reporting obligations. On the civil penalty side, you're looking at up to $25,000 for each violation, and these penalties are ongoing. So if you have a release and you fail to report it as you should have, on the day of the release, shortly after it is detected, and you are discovered to have not reported that release immediately, so each day that passes, you are subject to a violation or a penalty of up to an additional $25,000 per day. So you can see how those penalties will mount up very quickly. It also mentions that fact in terms of continuing violations. It says that in the case of a second or subsequent violation, any such person shall be subject to civil penalties up to $75,000 for each day the violation continues. So you actually have a tripling of the penalty effect if you delay in your reporting. All the more reason why, as a facility, you had better make sure that you err on the side of caution and report these releases, even if after the fact you determine it did not need to be reported. Much rather you go through the process of reporting than not, because of the penalties. Now, I mentioned before that criminal penalties also come into play. And of course, everyone must be aware of that fact, and the fact that not only can the corporation who owns the facility be prosecuted and fined criminally, but individuals who knowingly and willfully fail to provide notice as required can also be criminally prosecuted and fined. And there is no job worth going to jail over. So if you are a management level person or someone delegated with the responsibility to make sure reporting occurs upon the detection of a hazardous chemical release, that's another reason why you need to err on the safe side and report such releases. Now I want to show you an example of the federal government's listing in alphabetical order of extremely hazardous chemicals. And this is just one page from a rather lengthy section in this appendix that lists from A to Z all the different chemicals that are required to be listed on the toxic release inventory and reported if the reportable quantity of a release in any 24-hour period exceeds a certain threshold. Now, please note, by example, if you look at ammonia, there's a 100-pound per day release reporting requirement. And keep in mind that this release reporting requirement is not 100 or more pounds at a given moment, but it can be a slow leak that is detected after 18 hours, depending upon the chemical involved, that is detected later rather than sooner. And while the rate of release at the moment you find it may be, very small compared to, say, 100 pounds or 1,000 pounds, whatever, it's a 24-hour period in which you judge the quantity of the release. So lots of times these releases occur in one fell swoop, but not always. So the hazardous chemical that's subject to release reporting may have an odoriferous smell to it that, such as ammonia, that will be detected by the nose or by alarms that will alert people to the fact that there is a release occurring at the moment. So if you look up the extremely hazardous chemicals subject to EPCRA CERCLA reporting, this is what it looks like as a page. And it is something that I assume most facilities are aware of and know what chemicals on site are subject to reporting and hazardous chemical release reporting. So that's a good thing to know. Now, prudent advice within a facility is that you need to make sure as a chain of command that you have an emergency release and spill response sheet for management to have as a reference that will list the company contacts, people who are to be notified up the chain of command and down by people at the facility when a release is detected. The names and the contact numbers need to be listed and available. The federal and state and local governments are entitled to expect a facility to have such a listing available, along with a listing for the National Response Center, your state environmental response, and your local emergency planning committee, the LEPC, names and contact information for those individuals. So if you're a facility that is operating within close contact to another facility, you may also want to have contact information for the other facilities management team, because they may be impacted immediately by a chemical release caused at your facility next door, whatever, and you will want to notify them so they can take appropriate steps to possibly evacuate their people to avoid harm and injury. So you need to create that list of contacts for your own company or any immediately adjoining facilities who could be immediately impacted, and within the confines of the government, the federal, state, and local authorities to contact. The best advice I can give to any facility is to make sure you do your reporting as required by the law, your toxic release inventory, that you have in place people's understanding and knowledge as to what to do when a release occurs in terms of a reporting requirement. And of course, most importantly, that you have in place the training for all employees regarding evacuation of a facility. They know when to do it and where to go in order to avoid harm's way. So when you're managing this particular area of concern, you need to make sure that everyone in your facility understands the obligations they have, because failing to carry out the reporting and the release reporting and execution of evacuations from the facility can result in very serious civil and criminal penalties under the law. I appreciate the opportunity, and best of luck in your ability to manage those hazardous substances and chemicals in the facility. Thank you, and have a good day.